And so, Paul, how unusual indeed is this that a judge brings in friends of the court arguments in these pretrial moments?
Everything's unusual about this hearing, but I think that's kind of usual for Judge Cannon. There's no reason for there to be a hearing on this issue at all. The law is settled. The lawyers have filed briefs, and most judges would have decided just based on the briefs, they would have dismissed Trump's motion. There's no reason that Judge Cannon should be deciding this herself. Magistrates typically handle motions like this. The magistrate who would be responsible here is Bruce Reinhart. He has special expertise in public corruption. We worked together for several years doing these kinds of cases. So he knows this law way better than Judge Cannon. It's he who, again, just under typical procedures, should be handling this motion. And finally, Jose, the fact that she's allowing outside lawyers who are not representing either Donald Trump or Jack Smith to come and argue about this issue in her courtroom, it's just plain weird. Once again, the issue with Judge Cannon at this point is always, is it that she's incompetent or is it that she's biased in favor of the former president, or is it a little bit of both?
So, Katie, taking a step back, I mean, Trump was indicted initially in this documents case, exactly a year ago this month?
Yeah. There was a subsequent superseding indictment a couple months later, but this has been going on for a while.
And so how do you see the pace that this case has taken?
Well, I think it's common knowledge that the pace is just notoriously slow, and we're never going to see this case before November of 2024. I'm optimistic maybe it'll go in the beginning of 2025, but it all depends on these pretrial rulings. And let me be clear, there's more motions that are pending, Jose, that actually haven't been addressed yet by this judge. And these are substantive motions that need to be addressed.
Like
to have
what?
A
what
ruling.
Kind of motions?
Well, you have other motions to dismiss and other motions to suppress, and she did tee up those hearings, and I'll be there next week to hear a lot of them, and some of them are very important. Some of them deal with the attorney-client privilege issue regarding Evan Corcoran. As we know, Judge Beryl Howell in D.C. waived that attorney-client privilege based upon the crime-fraud exception. But I wanted to highlight something that came from oral arguments today. Emil Bovey, the lawyer for Donald Trump, said that attorney generals being able to appoint special counsels gives the attorney general the power to appoint a shadow government. So, Jose, we're now hearing oral arguments on motions that should be summarily disposed of by the judge. And by the way, if either side doesn't like the ruling, they can appeal it, right? So that's kind of what is the delay that's baked in here. She's allowing all of these oral arguments for hours. You let these outside third-party lawyers come in and argue as well. And then you delay a ruling. And because of that, it delays the ability for either side to be able to appeal because you need to have something to appeal. But then Cannon says, that sounds very ominous, a shadow government, but what does that mean? I mean, that question alone should make you question Cannon's ability to be able to preside over this case simply because you should not be entertaining that argument. The idea that a shadow government has been created by special counsel being appointed by the United States Attorney is absurd. And as Ken Delaney and aptly noted, this issue has been resolved by other jurisdictions. There's really no conflict in terms of what is going on.
The issue that Jack Smith was not confirmed by the Senate, is that
special counsel. Special counsel has been deployed. It's been used against people like Hunter Biden, as we know. I mean, this is not just a completely one-sided appointment process, Jose, and that is why the fact that we're having an entire day dedicated to the appointment challenge on the appointments clause of Jack Smith is absurd. Then Monday, let me be clear, what are we going to deal with? We're going to deal with the funding portion of Jack Smith on Monday. I mean, that's the type of time that's being wasted, which could be used for substantive advancement, which is why that Times article that came out by Charlie Savage and Alan Fuhrer was astounding.
Yeah, and Paul, I want to talk to you about that because according to this New York Times exclusive article, one of the incidents that motivated one of the judges to ask Cannon to step aside was when she stepped in and appointed a special master to go through the evidence seized after the search warrant was approved by a different judge. Now, again, in an unusual case of an unusual after unusual incidents, how unusual is that?
For two federal judges to suggest that Judge Cannon remove herself from presiding over Trump's criminal trial is unheard of. It's really not a basis of opinion, though, whether Judge Cannon is mishandling this extremely important federal criminal trial, not a matter of opinion, a matter of fact based on what the very conservative 11th Circuit did when it rebuked Judge Cannon not once but twice for mishandling issues with regard to the search warrant. So it's important to understand that one of the judges who suggested that Judge Cannon get off this case is herself a conservative judge who was appointed by a Republican president. She's the chief judge now. I think she's concerned about the legitimacy of her courthouse, of her the federal district that she presides over, because again, Judge Cannon is not making the rule of law, equal justice under the law. She's not making it seem as like those are important factors in her rulings and in her courtroom.